from fair housing principles to real-world application. In the previous section, we established that fair housing is not just about intentional discrimination. It is about the effect of our actions, our policies, and even our words. We discussed how advertising, steering, and unequal treatment can create violations even when an agent believes they are just helping. This same principle now extends into one of the most evolving and misunderstood areas of real estate practice: how criminal history is handled in housing decisions. The reality: a large portion of the population is affected across the United States. An estimated 70 to 100 million adults have some form of criminal record. Many of these individuals have minor offenses or issues from years in the past, yet they often face significant barriers when trying to buy or rent a home. While criminal history is not a protected class under the Fair Housing Act, how it is used can still result in a violation of fair housing laws. This is where the concept of disparate impact, introduced in the previous section, becomes critical. Fair housing still applies, even when not obvious. The Federal Fair Housing Act prohibits discrimination based on race, color, religion, sex, disability, familial status, national origin, 42 U.S.C. paragraph 3601 et seq. Even though criminal history is not listed, policies that rely on it can still violate the law if they disproportionately affect protected classes. Disparate impact, connecting the dots. As discussed previously, a violation does not require intent. It only requires that a policy creates a negative effect on a protected group. Example: a landlord says, "We don't rent to anyone with a criminal record." At first glance, this seems neutral. However, because certain racial groups are statistically impacted at higher rates by the criminal justice system, this policy may result in discrimination based on race, even if that was not the landlord's intention. This is exactly how fair housing violations occur in modern practice, through overly broad policies that ignore individual circumstances. HUD guidance: what agents must understand. HUD has made it clear that housing providers must avoid blanket bans and instead apply a more thoughtful case-by-case analysis. This means evaluating the nature of the offense, the severity of the conduct, the time that has passed. Example: an applicant had a nonviolent offense 15 years ago and has had no issues since. A blanket denial without further consideration could be viewed as unreasonable and discriminatory. Arrests versus convictions, a critical distinction. Another key point is understanding that arrests alone are not proof of wrongdoing. They should not be used as the sole basis for denial. Convictions may be considered, but only if they are relevant and necessary to protect safety or property. Example: an agent advises a landlord to deny an applicant because of an arrest record with no conviction. This creates serious legal risk and may violate fair housing standards. The three-step legal framework. To determine whether a policy is compliant, courts and regulators look at three factors. Does the policy have a discriminatory effect? Is it necessary to achieve a legitimate, non-discriminatory purpose? Is there a less discriminatory alternative? This ties directly back to the concept introduced earlier. Just because something is allowed does not mean it is compliant. Real estate professional application. Your role matters. Even if you are not the decision maker, your guidance matters. Example: a landlord client says, "I don't want anyone with any kind of record." A compliant response would be, "We need to be careful with blanket policies like that. Let's make sure your criteria are reasonable and legally compliant." This is where you move from being just an agent to being a professional advisor. Assistive animals, another area of common mistakes. This section also connects to another major fair housing issue: reasonable accommodations for disabilities, particularly involving assistive animals. Under the Fair Housing Act, housing providers must allow service animals, emotional support animals, even in properties with a no pets policy. Real-life case example: when policies go too far. A housing provider implemented a complex and restrictive process for approving assistance animals, including multiple forms, medical record requirements, breed restrictions, annual renewals. This policy was found to be overly burdensome and resulted in legal action, financial penalties, required policy changes. The lesson is clear: you cannot create barriers that effectively deny someone their fair housing rights. The professional standard moving forward. Just like advertising and communication, fair housing compliance requires a consistent mindset. Avoid assumptions, avoid blanket policies, treat every situation individually, focus on facts, not fear, bringing it all together. This section builds directly on the last. We learned that Intent does not matter. Impact does. Words and actions both create liability. Fair housing applies to every part of the transaction. Now we add one more layer. Policies and practices must also be fair, reasonable, and narrowly applied. When you combine clear communication, independent decision-making, fair and consistent treatment, you protect your client, your license, your business, and most importantly, you help ensure that housing opportunities remain open and accessible to all. Online discussion. Question: why can criminal history policies create fair housing violations? Answer: because they may have a disproportionate impact on protected classes, even if they appear neutral. Question: what is the difference between an arrest and a conviction in housing decisions? Answer: an arrest does not prove wrongdoing and should not be used alone, while a conviction may be considered if relevant and justified. Question: what is the biggest risk with blanket policies? Answer: they fail to consider individual circumstances and may create discriminatory effects.